Mrs. Chowdhury, let's start with the definitions under this Act, which are so wide as to be worrying. To begin with, there's the whole question of what the Act means by the term domestic violence. It covers verbal abuse, emotional abuse, economic abuse, and anything that tends towards them. I put it to you, that's so wide as to be either meaningless or dangerously self-embracing.
I don't know why you have to see it in two extremes. Why have you not ever noticed that women live in dangerously self-embracing situations? That none of this, even if you see it as a porosity in the Act or that the ambit is too wide, please understand that women are burnt to death, beaten to insensibilities.
But the cure is not imprecision. The cure is not vagueness of legislation.
Absolutely.
Let me explain to you why this Act is imprecise. For instance, emotional and verbal abuse are defined to include insults and ridicule. That means that you can't be sarcastic to your wife. It means that you can't call your brother-in-law an ass or your mother-in-law a nag, even if both of those are correct. Surely that's a level of silliness, but it's part of your bill.
I want to tell you, what you deem as silly is really not something that I have created today. Under the IPC section, speaking in a way that is denigrating to the status of woman, which removes her from her dignity, is very much an act under the IPC. So I don't see what you're getting het up about today.
Except that here you're interfering in the normal conversation between two adults. As Soli Swarajji writing in the Indian Express pointed out, you're reducing an important and serious issue to the level of silliness.
I don't think anything that happens to a woman in the sense of her domestic violence can be termed as silly.
Let me take another example.
It is over-trivializing and oversimplifying this act. Please understand, despite all the checks, women are burnt. 1 in 6 women is raped, murdered, beaten to death, sent into mental asylums. I don't think
that's not what your Act concentrates on. Look, for instance, at economic abuse. Let me give that as another example. It's defined by the Act as deprivation of any economic or financial resource which the aggrieved person is entitled to by custom, and it includes disposal of household effects. Under that language, if a husband was to sell the family television at a time when his marriage was going through a bad patch, it would be deemed to be domestic violence. Now that's ridiculous.
Is it any more ridiculous than the fact that well-to-do men suddenly turn around and claim that they have no money, that they're bankrupt because they have to pay alimony to a woman, where the human dignity is involved?
But what your Act has done is to take trivial issues that could happen quite innocently and convert them into offences and crimes.
I don't agree with you, Karan. We are saying we are facilitating and setting up a legal framework whereby we expect... Please listen to me.
An insufficient legal framework and a precise one.
I must be allowed to talk, otherwise this is deemed as domestic violence. This is professional violence.
You're proving my point.
Absolutely.
A mere interruption becomes domestic violence.
This is an overrun. It's an interpretation of what is an interruption and a verbal overrun.
Don't you think you're proving my point?
You may think so, but let's wait for what the others think so. But I want to tell you what I think so. I think that if there is harmony within a house, there is nothing for anyone to fear. But if there is complete disharmony, where one partner is completely incapacitated, made to be dependent on another partner, and they are harassed in, you have no idea how many ways.
That is a biased statement which you're elevating into a principle of false philosophy. The reason that in fact it doesn't sound true is very simple. Look at the range of people covered by your Act. It talks about aggrieved persons, and aggrieved persons are defined as any woman who is or has been in a domestic relationship. And then it defines, let me finish, then it defines domestic relationship as a relationship between two persons who live or have at any point of time lived together in a shared household. Put them together, and your Act covers not just wives, but wives who've been divorced, girlfriends who you've separated from perhaps as long as a decade ago. Why are those included in the ambit of this Act?
Why? Because women, even in those relationships, have been harassed and held to ransom. There have been enough divorced women who have been divorced because of various reasons, and their money is not returned.
Women have a decree that has been given by a court, an alimony that is given by a court. The divorce has been adjudicated, it's legal, so there's no need for you to interfere.
Fair enough. Let us assume that there is no need for us to...
Don't assume, it's a fact.
Okay, if it is a fact. But please tell me, do you think that a woman is given a divorce easily, where a man doesn't want
When a divorce is given and granted by a court, there's no need to go further back in the picture. But you do.
If you do,
yes, this bill
I'll tell you why we do it. I'll tell you why. If a man violates his custodial rights, if a man violates his restraint order, If after a divorce a husband keeps stalking me or harassing me, if a man turns up and smashes my windows,
that's not the thing
you think
that
it
your
doesn't
act
happen,
concentrates
Mr.
on.
Karan
No,
Thapar?
it may happen, but that's not what your act concentrates on. Let me point out to you. Clause 3C doesn't just limit the ambit of the act to former girlfriends you separated from or former divorced wives. It even talks about any person related to the aggrieved person, which means that it's not just the former girlfriend, arguably it's her step-brother as well. This is becoming ridiculous at this stage. It means, let me interpret this view, it means that a husband cannot threaten to verbally abuse, note the words, just threaten to verbally abuse the step-brother of a former girlfriend who he parted with 10 years ago. That ambit is taking a major concern to
I
a
tell you, you're
ridiculous
looking
extent.
at such extremely ridiculous situation.
It's part of your bill.
You should be
It's part of
writing
your
to
bill.
that for the television series. But I want to tell you,
I'm afraid your bill seems to cater for it. That's the problem.
Okay, if that's how you interpret it, but a man would.
Well, it's not a question of a man would. The reason that I'm pointing out the ridiculous extreme is because laws are always judged by the extremes, not by the middle position. And what your law does, because of the wide ambit of the definition of domestic violence and because of the long range of people it covers, it tends to convert innocent husbands into offenders and criminals. And worse, let me finish, worse. It gives the power to motivated women who want to be vicious or, forgive me, bloody-minded, to get away with such behavior. That's why it's potentially dangerous.
Karan Thapar, you have to understand that this bill addresses a family as a unit within a prescribed legal framework. If the innocent husband, as you call him, is innocent and his behavior and attitude to his partner in life is of mutual respect and concern, there is no anxiety. There is no anxiety for men to suddenly feel victims.
But the point is how you define the offense you hold him guilty of. Sarcasm becomes an offense. Calling your brother-in-law an ass becomes an offense.
And
that's why it is dangerous. Well, it does.
That's your personal equation. If your brother-in-law and you are not happy with each other, you're going to look at excuses. But if there is basic harmony, and you call a friend and a brother-in-law an ass who's a friend, he's not going to take you to court,
why this is such a dangerous act. Critics are pointing out that this act is going to go the way of the anti-dowry law. It's going to be deliberately misused. Let me point out what the Supreme Court said in July 2005 about the anti-dowry law. It said, many instances have come to light where the complaints are not bona fide and have been filed with an oblique motive. In such cases, acquittal of the accused does not wipe out the ignominy suffered during and prior to the trial. Sometimes adverse media coverage adds to the misery. Your act is going to go exactly the same way as the anti-dowry law.
I want to tell you, when we bring out an act, we help set a direction for a certain societally accepted behavior. Those are the broader parameters. Because of a minute percentage of people who misappropriate the act, are you saying that I should not bring an act, I should be in denial that women are not domestically harassed,
Let me answer your question.
They are not killed, removed from their home, denied access to their children, to their own earnings, and that they have no recourse to law?
A minute percentage of people?
Yes.
The Center for Social Research with regard to the anti-dowry law did a study after the Supreme Court judgment came out in August of 2005, and it concluded that of every 100 cases brought under the anti-dowry law, 98% were false. Only 2 were correct. It's not a minute percentage. The level of abuse that this would incur would be phenomenally high.
No
it's okay. It's acceptable.
It is not acceptable, Karan Thapar. You don't put words into my mouth or try to get me. No, I am very clear about it.
All right, when the minister says okay, she means it's not okay.
No, if you want to say it that way, if you're being clever with words. But kindly listen, the law is not a static issue. Law reflects the need for a society to be given direction. We have put in broad parameters and we will see in which direction this law goes.
Okay.
But even if the statistics are telling you that 98% of the cases reported are violated and are wrong, please tell me the statistics of how many women are killed every day,
Let's take up
forced
the issue.
into abortions, raped against their will, denied access to society and property. Tell me those statistics and we'll talk about it.
There's no doubt that women in India need protection. I don't
from
deny.
home.
There's no
From
doubt.
whom?
Let me finish. There's no doubt that domestic violence is one of the worst features of our society. The problem is that you're protecting women. Let me finish.
What
You're
are the
protecting
you never
women
let me
at
finish.
the cost of exposing men to gross injustice. That's why this bill is wrong. You're creating one
Karan
right
Thapar,
against another wrong.
Why didn't you do 2 rights in your shows earlier for those women who have no access to any justice in this country despite the establishment
But
of
you
laws?
don't have to give
Are
them
there no
access
laws
to
on
justice at
sati?
the cost of
Are
men
there no
becoming
laws
treated badly.
I
That's what you're doing.
This is
You're
not what
exposing
we-
men to
No.
injustice, to harassment. You're exposing
We are
men,
not.
in
We
fact,
are
to
not.
mistreatment.
We are not.
Can I pause? You keep talking about the direction. You keep talking about the importance of setting a direction for society.
Yes.
I want to question you on that. Clause 17 of the Act gives divorced women and former separated girlfriends, and I use that language very carefully, divorced women and former separated girlfriends, the right to claim residence in the home of their former husband or their former partner, even though the Act says they may not have any right, title or beneficial interest in the same. What's the justification for that?
Because a woman is removed from her house. She is threatened, coerced,
divorced
forced,
woman
and
has
you
a-
have an
a-
ex-parte divorce
A
which
divorced
has been
woman has a
granted.
decree nisi granted by a court.
No,
She
no,
has an
certainly
alimony
not.
granted
There
by
are
a
plenty
court.
of divorces. I cannot
A divorce
accept that
can only
every
happen
divorce
when
has
a
been
court
examined
gives
in
it.
its... You can say what
A
you
divorced woman has an annulment. A divorced woman has an alimony
No,
given by a
no,
court.
not
Surely, it will
necessarily
take it
on,
into account.
on the merits of the case, not at all.
Are you saying that the judges
Yes.
are wrong?
Maybe.
Are you stepping in to correct what judges
I
have
am
done?
not correcting what judges. I am empowering my women to have the right to access the dignity to their life. If they have been denied justice on other forums, if they have been given
But
an
how-
ex-parte divorce in the absence of theirs, if they have had no money to go and appeal in a court and they're denied their right, and if the husband suddenly
You see my
declares he's
point?
bankrupt
You see my
and
point?
not given an alimony.
You just qualified the problem by adding 6 different ifs. Your law, however, doesn't add any of those ifs. Clause 17 begins with the phrase notwithstanding anything in
Read the
any
full
other
clause.
law in operation in this
Read-
country.
read
I am
the
reading
whole
it.
clause.
I am
So-
reading it.
so-
It says notwithstanding any other law in operation anywhere else in the country. Despite that, divorced women and former girlfriends have a right of claim in the residence of their former partner or former husband. So none of your ifs qualify. If you had put the ifs into the law, I'd understand.
All right,
But you
so-
don't. You need
so-
to amend it
All
to
right.
actually incorporate your position.
All right, we'll
You
see if
accept
the
it.
need arises. We'll do it first. Let it come into being.
It has.
It has.
On the 26th of October, it
and
came
rather
into
well,
being.
and rather well.
So now,
far we haven't
now
had
you
any
accept-
complaints
so
about
now
the
you
misuse
accept that
of
with
law.
limited reference to clause 17, there is need for amendment.
There is
for
always
correction.
need for corrections and amendments in any law as we progress, as a society develops, and the needs arise. But for want, hypothetically, before I reach the bridge and cross it, if you want me to make amendments, I won't.
In other words, let men suffer first, then I'll correct the wrong
That's
I've
not a
done.
bad idea, except that I have such pity for men.
All right, let's take a break at that point while you're still smiling, and let's come back and point out more adversities. We'll be
Go
back in a
ahead.
moment's time to a minister who seems to enjoy creating trouble for men. See you after the break.
Enjoy. We've been victims of trouble from men already.
Mr. Chowdhury, I put it to you that the great danger of the Domestic Violence Act, which came into force on the 26th of October, is that in the hands of a bad judge or a good prosecuting attorney, it can be used to harass innocent men, to entrap innocent husbands, and deny them justice. That's the danger of the imprecision, of the loose wording, and the huge ambit of so-called offences included here.
All right.
You accept?
They may be.
What do you mean, maybe?
If you're saying so, you're so convinced of it.
But
So are
in
you
which
going to
case-
even listen to what I have to say?
I have been listening to it at great length. You now seem to be agreeing with me.
And we don't have an agreeable concept of what is listening.
But tell me something. If you accept that this act in the hands of a bad judge or a clever prosecuting attorney can inflict injustice on innocent men, then does it not need amendment?
Mr. Karan Thapar, every law in this country is in the hands of a bad judge and a clever prosecutor.
Then why add to the
It is
problem?
nothing new or unique, the situation. So hence, when we have bad judges, your words, and clever prosecutors, your words, where do the women of this country take recourse to regarding
But do they
the
need a bad
situation
law?
that they live in?
That's the problem. You're
It is-
adding to the situation
you
of bad
may-
judges by giving them a bad
You
law.
are only telling me the bad law for men.
But
It
that's
is not a
50% of
bad
the
law
Indian
for
population.
women.
But that's 50% of the Indian population.
Yeah, but my tragedy is that I have women who are no longer even 50%
Do you
of
really
this
believe that you
population,
can't do
that I
justice
have
to
sex
women without
ratios.
doing injustice to
I
men?
don't want to do injustice to
But
men.
you're
In
doing
this
it.
case, they don't
You've just
get-
done it.
If you see it that way, is it injustice against women that we've had rape laws in place and dowry laws in place, and they have never been adhered to, that women are killed every
of the
minute?
cases brought under the dowry law, as I told you in part 1, turn out to be false, a statistic given by the Center for Social Research, if the Supreme Court itself has opined on the subject roughly at the same time last year, then surely you don't need to add to bad laws by creating more.
Yes, hello, can I tell you that it's the courts which have been proactive. It's the High Court which has just recently ruled here, saying that for 7 years after the woman is married, for 7 years, please listen to me, that the family will be held accountable for her death. Why would a court take that extreme order? Do you think that that is a fine law?
Yes.
Do you agree with the opinion of the court?
But I'm not talking about murder. I'm talking about offences that are just limited to sarcasm.
They're talking about
I'm talking about sarcasm to the stepbrother of a former girlfriend covered by this law. That's why it's a bad law.
Stepbrother of a former girlfriend, it depends on a one-to-one.
Let me give you another
example.
example.
You don't have to be a relative of a woman for sarcasm. As a citizen, if you misbehave with another citizen, under the IPC, you can be held up.
Let me tell you why
there is very little that is new.
Let me point to you why this is in fact a dangerous law that can be misused in the hands of bad judges or clever prosecuting attorney. Clause 4.1 says, any person who has reason to believe that an act of domestic violence has been or is being or is likely to be committed can inform the authorities with no liability if he or she is wrong. Secondly, at that point in time, a magistrate can impose a protection order that can severely restrict the rights of the accused. You're creating a devilish situation entirely on the basis of mischief makers and tittle-tattlers snooping around.
Maybe initially you will have the tittle-tattlers, you will have everything. But I also like to believe that maybe we save so many lives where we know the in-laws are planning to kill them or force her into a sati death, or
you may also end up trapping innocent in-laws because paramours and other malignant people.
Innocent in-laws, you have nothing to worry.
You know the problem with clause 4.1?
Innocent in-laws live in harmony with their daughters-in-law.
But the problem is that mischief makers create trouble where there is harmony.
Mischief makers do create trouble everywhere. It's mischief makers who don't tell us that women are forced to come or are opiated and forced to commit sati. It is mischief makers who report on income tax laws, if you remember earlier. May I remind you?
You don't need a law to tackle sati.
Of course you needed a law to tackle.
It's already a crime in India. You don't need a new law.
Sure, but what are your success stories?
Let me point out. You know the let me point out the problem with clause 4.1. It permits anyone who is inimical to you, leave aside an enemy of yours, to go and mischievously and maliciously report on things he claims you're doing and get away with it. In fact, it even permits your wife's paramour to turn up and make mischief against you and to do so with impunity.
Yeah, but I'll tell you something, Karan. Irrespective of that, these are preventive checks that we are putting in. You think the law is an ass that they'll suddenly come and arrest you without...
this law is an ass.
Okay, fine.
That's exactly what I'm saying. This law is
that's
close
your
to being
opinion.
asinine.
That may be there, but I want to tell you, there are very few sections under this law which are not existing under the IPC
in which
already.
case you didn't need it, it's redundant, so why do you think
It's not redundant, we are empowering the IPC to do it. Delhi has reported that in the last year, 8,000 marital discord cases were reported to the police, and there was little the police could do. How do you answer that?
Let me end with one simple question. From Soli Sohrabji to ordinary Indians, there is grave concern about the imprecision and the dangerous wording and the dangerous ambit of this law. Are you prepared to listen and amend it?
Of course. We are prepared in a democracy to listen and respond to a situation that could be an aberration on a societal fabric.
But you're going to wait for the situation to happen and then you're going to respond.
That does not deny the right for us to bring about a law like this.
Even if it's a bad law.
It is an unmet need, and the women across the country have not yet
You're saying to me that a bad law is better than no law at all?
If you want to see it that way. Any law is better than no law at all.
A pleasure talking to you on Devil's Advocate.
Well, thank you, but be careful.